Well, first of all, thanks so much to the Originalism Center for letting me present a draft of this paper on its judicial restraint, part of the originalist method. Since everyone has read the paper, let me be brief and hit a few highlights of the paper and put it, I think, at least two of the points in the larger context of what's going on in originalism. Because one of the other trends in originalism, I think, is to understand the original Constitution as not a document that's created ex nihilo, but is put in already pre-existing legal space. And the understanding that's offered here of the judicial restraint comes from that it's part of the judicial duty, which is itself needs to be understood in the background of judicial power. I think this move, and there are many moves, many papers in this area. I think of Steve Sachs' Constitutional Backdrops. I think of some of the substantive work in reclaiming some of the Scottish background of my colleague Jim Fander, is an important move. And if I may make an analogy to the sublime to the earthly in this respect, that I think at one time, of course, it was thought that space really didn't have itself any properties. That was sort of the Newtonian idea of space. That's not our idea of space now. It's that space really gives weight to different particles. And I think the same thing is true of the legal space into which the Constitution is made. We really can't understand the Constitution unless we understand that legal space. And I think this is the way of understanding this paper as an attempt to, either through understanding judicial duty as part of judicial power, as either understanding it as a backdrop, or perhaps, I think less importantly, as a original method, it's an attempt to recognize that is the best argument for judicial review, and if that is the best argument for judicial review, that it is part of a pre-existing understanding of what judges did for the judicial duty that was an aspect of their judicial power, it is certainly reasonable to investigate how they understood the application of their duty and whether or not judicial restraint was a part of that duty. And so that is, I think, the first important move of this paper, which, as I suggest, is really a part of, I think, the move generally in originalist scholarship. The second aspect of this paper is to just look at the evidence, and it really looks at two kinds of evidence. One, it tries to look at the background because it recognizes there are a lot of comments that suggest that judges should only strike down legislation if the constitutional meaning is clear. How could one understand that how could they have understood that as a matter of legal obligation? And I look at the background of the origins of deference that Philip Hamburger has found in English law. Look also at the sense that goes along at the time of law as a legal science, because this paper sees judicial deference on the one hand. On the other hand, it sees the confidence in that era of actually finding meaning through legal science. And finally, it looks at judicial review and Republican theory and suggests that Hamilton is very consistent with the rather modest understanding of judicial deference offered here. Then it goes on to look at some of the evidence, and I think the evidence is very substantial that there is some modicum of judicial deference. How one actually formulates that, in the paper I suggest that you only should strike something down as a judge if you can come to a view that the meaning is clear and stable. That has a variety of supports for it. One of the striking things is, I think, how you can find support for that. Again, I suggest in the background of the Constitution, but then in cases before the Constitution, in state cases of judicial review, in the debate at Philadelphia, in the pre-Marshall court, in the Marshall court, and in the state courts in the early Republic. And I think these tend to be rather similar, and one of the striking things is how jurisprudential it is and not political, that it really doesn't seem to matter much whether judges are reviewing state laws or federal laws, rights provisions or enumerated powers provisions, they seem to bring that same understanding. There may be a few exceptions. Some of the later state cases after the Constitution, I think, are a little more extravagant in praising restraint. There's also a case that might suggest that you should have more restraint if it's a judicial power because judges should be self-interested. But I think those are really not with the weight of the evidence, which is, I think, suggests a kind of relatively consistent view of judicial deference. But again, it's very important to understand that judicial deference is not what is most famously understood as judicial deference, which of course is in Thayer's own explication of these cases in Thayer's famous article calling for judicial deference. And the reason is that he doesn't seem to grasp, as I try to point out, that judicial deference is allied with a confidence in the ability of judges to clarify the Constitution. And that means two things. First of all, it is not the case that judges will defer so long as any meaning of the text of the Constitution permits it. Moreover, it's not the case that they think that meaning, as Thayer does, that there are irreducible gaps in the Constitution that the legislature might as well fill. That's completely absent, I think, from the framers' understanding. And then finally, Thayer, I think, just simply has the wrong standard. He has a kind of rational person's standard, and a rational person who is not informed by all the legal methods that are used by courts at the time. So it's a fundamentally wrong view of judicial deference, and I think that stems, not surprisingly, and this is always the danger in originalism, from Thayer's own jurisprudence, which is very much influenced by a view at the time that judges are lawmakers, a view that I do not think is largely shared at the time of the framing. And so I think he actually makes a clear mistake in delineating deference. Well, the final point of the paper thinks a bit about how should deference be understood in our day, and I think this goes to yet another move in originalism. The idea that originalism may get better today, our understanding may get better today, because the data today that is available to us to understand what words and concepts mean in the Constitution are actually greater than the data that was available to judges at the time. Of course, we all hear about big data, and I think it's coming to originalism. I think we've already seen excellent examples of that. I'd refer to Randy Barnett's paper on the Commerce Clause as something that one could not imagine being done at the time of the framing, and certainly not available to judges. Well, that actually might have implications for how deference is applied today, because just as the Commerce Clause doesn't change its meaning, it may increase its scope because there's more commerce. It may, given that we have more information, it may be that there'll be less times that we'll have to say something is not clear. That's true, at least, if we agree, I think, with the founding generation, that other than the text, we have a variety of methods that actually narrow the scope of difference in the possible interpretations. If we agree with that, and we think we have fuller information to apply these methods, I think it follows that there actually may be less times when judicial deference is going to be decisive. So note, this is, I think, an interesting aspect of originalism. If one believes that, it's not that original meaning changes, but it may be that because of the facts of the world change, we actually may be able to be more certain of our results than before, and that actually may change the frequency on which we rely on judicial deference, not unlike a world in which sort of God looks at the criminal law. He would never have to decide that someone was innocent because it couldn't be proven beyond a reasonable doubt. He'd only decide it because the person was innocent in fact. I don't think we're quite there with respect to originalism, but I think it's important to think of the changes that are going on in information as a way that actually may transform the way, not only the way originalism is practiced, but the importance of something like the deference idea. Thanks.